This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
My lord, 89, my lord, I am for the petition, it was continued. The opposition, they were
Yes. I have tagged it together so that the issue can be decided in one go. Otherwise, it will be a problem.
Group D expiry is under challenge. Taito.
Show certain documents. Yes. In these
Maybe Group C and Group D, but the
Issue is
same
Same.
whether the candidates appointed after expiry of the panel is to be brought under the tainted list.
And my lord, 91 and 92 also the same issue.
Yes, that is the reason they have been tagged.
there are subject to corrections. There are applications, my lord, wherein we had to file affidavits. My lord, we had served the other sides. We had prepared the affidavits. My lord, these are not voluminous as was there in last occasion. May we file these affidavits, my lord? This is one of such affidavits.
By the candidates appointed after expiry of the panel?
Yes. We had taken out applications, my lord. Those are on record of your lordship.
And
15, 16.
have you all been implemented as parties?
Can 15, 16s are allowed?
My lord, there are two cans, my lord, which have not been allowed, my lord.
Yes.
I would request your lordship, my lord, all have been allowed every day. This will continue, my lord. I am only relying on up to
Opposition
whichever
of
can has been
the
allowed.
commission.
I will not give any reply. But my lord, kindly do not allow any further addition of party, my lord, otherwise it will continue. No, my lord.
Just wait. Please wait. Yes. Let the petitioner make submission.
We have given them the copies.
All right. Start.
My lord, on the last occasion, my lord, I was placing, my lord, I started from the order passed by the Honorable Supreme Court, my lord, paragraph 20 and paragraph, my lord, 31, which says, my lord, paragraph 20 affirms, my lord, the order passed by our division bench that after appointments given after expiry of panel, my lord, is illegal and they are considered to be tainted. And subsequently, my lord, paragraph 31 of the Supreme Court judgment says, my lord, that appointments which have been given for classes 9, 10 and 11, 12 after expiry of panel is illegal, and my lord, all the justifications that were made were not considered. Now, my lord, I also on that day, my lord, I placed the 2016 rules. Rule 15, my lord, I say the validity of the panel, it says it's 1 year from the date of publication of the list. And my lord, the commission did not have any power in terms of rule 15 to extend the validity of the panel. Up to that, my lord, I submitted. Now, my lord, I would like to place the opposition of the commission. Commissioner opposition.
ওইটা দিয়ে বার করে রাখছি এই তো এখানে 9 জন
Yes.
My lord, straightway come to my lord, page 9. The lordship has come.
Page 9.
Page 9, my lord, under the heading counseling process for teaching staff for classes 9, 10.
Yes.
My lord, at the bottom. My lord, I am reading Roman 2. The panel for classes 9, 10 was published on 12th March 2018. My lord, kindly mark this date. The first phase of counseling could be started only on 6 September 2018. That is almost 6 months after publication of the panel. My lord, kindly note 6 September 2018. In their opposition, they are saying the date of the first counseling. My lord, thereafter, Roman 3. The delay in appointment was caused by an order dated 11th November 2016, which was passed in Swanso, wherein the validity of Rule 8(4) of 2016 rules was under challenge by some contractual teachers who were desirous of participating in the 2016 selection process for classes 11, 12. My lord, this is for 11-12, not for 9-10. For 11-12, the Honorable Single Judge of this Honorable Court on 11th November 2016 directed the School Service Commission not to issue any recommendation for appointment and not to grant any appointment without prior leave of this Honorable Court. My lord, here I stop here for a moment. My lord, I accept what has been stated. The order is annexed. I am not disputing. The order is, do not issue any recommendation without leave of the court. There was no bar, my lord, on conducting the counseling process. And secondly, my lord, this order relates to classes 11-12, not 9-10. My lord, thereafter, appointment without leave of the court. In WP number so and so, although the recommendation process was stayed for the candidates for classes 11-12, since a large number of candidates were common for both group classes 9-10 and 11-12, and the underlying issue was analogous for both the selection process, the counseling process could not be started for classes 9-10 as well. My lord, here, my lord, this is absolutely a, my lord, wrong statement. Why? Firstly, there was no stay on recommendation. Thirdly, my lord, the panel of classes 9-10 and 11-12 were published on different dates. So 11-12, even if there is a stay on the process of issuing recommendation without leave of the court, it has no bearing, my lord, on the counseling process of classes 9-10. Thereafter, my lord, Roman 4 at page 11. The order dated 11th November 2016, that is, my lord, the earlier order, could be modified on 25th of July 2018, when the commission was granted liberty by this honorable court to recommend for appointment and grant appointment to all successful candidates of the 2016 selection process by keeping the exact number of seats vacant as the writ petitioners in the 4 writ petitions. Thereafter, my lord, page 12, Roman 5. Despite the modification of the order dated 11th November 2016, on 25th of July 2018, the first phase of counseling for the subject Bengali could not be conducted due to a direction issued in so and so, by which the operation of the vacancy list in the subject of Bengali was stayed as an interim measure, as an interim order was passed, thereby restraining the commission from completing the selection process in respect of 86 vacancies. My lord, this was only in respect of subject Bengali, that too for 11-12 in respect of 86 vacancies, not the entire thing, my lord. Thereafter, my lord, page 13, Roman 7. Kindly see, my lord, the ground taken. It is stated that after the conclusion of the first phase of counseling, the second phase of counseling was delayed due to a major law and order issue arising out of the vacancy problem. It could be conducted on 5th February 2019. My lord, and law and order issue, they are the state authorities and they are not cannot control it, and they are taking a ground that because of law and order issue, counseling could not be conducted, my lord. Kindly see the steps of the grounds of the commission. Thereafter, my lord, it is stated that notice for third phase of counseling was published on 8th March 2019, and the counseling took place on 26th March 2019. My lord, admittedly, as your lordship has seen, the list was published on 12th of March 2018. And my lord, the third phase counseling was conducted on 26th of March 2019. So, my lord, it is an admission that third phase of counseling onwards was after the expiry of the panel. My lord, again, paragraph 9, it is stated that fourth phase of counseling which started on 20th September 2019, page 14. The fourth phase of counseling was delayed due to model code of conduct imposed in line of the 2019 parliamentary elections. My lord, your lordship knows, my lord, a process which was started way before the parliamentary election and it was continuing, my lord. The model code of conduct is not a bar in continuing with that process, my lord. I need not to, my lord, show, my lord, any side judgments, my lord. Your lordship knows better, my lord. This is not applicable. This is the ground they have taken. My lord, then Roman 10. Kindly see, in view of the inevitable delay caused in initiating the counseling process due to the orders passed by this honorable court as well as the administrative delay, the commission fixed the date of expiration of panel for classes 9-10 to be on 19th December 2019, that is exactly 1 year after the counseling of subject Bengali could begin. Here, my lord, I will again fall back to the 2016 rules once. 2016 rules. এখানে আছে না এইখানে মানে 2016 rules I have given your lordship a copy.
Yes.
মানে 2016 rules rule 15 দেওয়া আছে মানে rule 15 validity of the panel. My lord, once again I am placing each panel and waiting list shall remain valid for 1 year from the date of publication of the panel and waiting list or the date of advertisement for the next selection process, whichever is earlier. Here, my lord, it should be from the day 1 year from the date of publication of the panel. Now, my lord, Roman 2 and provided that the names of candidates shall not be recommended against any post other than the post applied for, my lord, not applicable. 2, notwithstanding anything contained in subsection 1, a panel waiting list, merit list prepared by each of the regional commission before coming into force of these rules, such panel waiting list, merit list shall remain valid according to the rules prevailing. So, my lord, this is also not applicable. So, my lord, rule 15 does not provide any power to the commission to extend the validity of the panel. My lord, rule is very specific. It is 1 year from the date of publication of the panel. So, my lord, whatever has been stated in paragraph 10 that the panel has been extended up to 19th December 2019 is absolutely bad in law. And my lord, the panel was published on 12th of March 2018. Thereafter, my lord, kindly come to 11. It is stated that even after the 7th phase of counseling in the 2016 selection process, kindly read this, man, interesting, a large number of vacancies were unfilled due to abstentionism of selected candidates and non-joining. On the other hand, a large number of candidates on the waiting list were making representations for their appointments. Since the commission was prevented from holding further rounds of counseling which would have been sufficient for filling up of all the vacancies by various legal and administrative exigencies for which none of the candidates could have been faulted, the commission decided to hold another round of counseling for filling up the remaining vacancies in the interest of schools of West Bengal and for the benefit of students. Here, my lord, the Article 12 authority is deciding to give appointments on the basis of the representations of the waitlisted candidates after expiry of the panel. My lord, where are those representations annexed? Those have been made. We all know, my lord, what happened in those agitations and those representations. And my lord, our division bench has hold that during those agitations and representation, a so-called super committee was formed with the then education minister, and all these everything happened, my lord, every corruption and everything, and this is part of the record, and this has been upheld by our division bench as well as the Supreme Court. And my lord, paragraph 12, Roman 12, the 8th phase of counseling was envisaged to be conducted during March, April of 2020. My lord, kindly see this statement. You all know what happened, my lord, in March and April 2020. The COVID. But the same was further delayed due to the nationwide lockdown imposed by the government of India in view of so and so, my lord. After the lockdown conditions were somewhat relaxed by the government of India, the 8th phase of counseling was conducted. It is stated that during the 8th phase of counseling, the candidates were recommended by the commission strictly based on their merit through a transparent process of counseling. The recommendations were made strictly in terms of the ranks of recommended candidate in the select list. My lord, this is absolutely uncalled for and bad in law. Now, thereafter, my Roman 13. After the conclusion of the 8th counseling by the commission, it was discovered that Around 102 vacancies were lying vacant for classes 9-10. Several waitlisted candidates approached the Honorable High Court seeking appointment to those vacancies. On 14th December 2022, the Honorable Single Bench of this Honorable Court, while considering a batch of writ petition, including so my lord, noted that about 102 posts of classes 9-10 notified in 2016 selection process were vacant due to non-joining of rank jumpers. The Honorable Single Bench thus directed the Commission to hold counselling in those 102 vacant posts and recommend candidates in terms of their inter se merit and position in the select list of first SLST. My lord, if your lordship kindly remembers, paragraph 31 of the Supreme Court judgment, take note of all these orders, says that in stray cases of rank jumping, the court passed an order of recommendation after expiry. At that point of time, it was not within the knowledge that corruption was at large, and so those orders cannot be taken as a defense. So, my lord, the Supreme Court has even directed that the orders which were passed by the High Court after expiry are also bad. My lord, thereafter, they have stated in paragraph page 17, Roman 15. Additionally, on 30th August 2022, these Honorable Court directed the Commission to appoint 2 candidates who were called upon to attend 8th counselling, but they could not attend the 8th counselling for alleged lack of proper information. My lord, these are all after expiry. I am not repeating, my lord. They are just giving the reason why, but they are not at all sustainable. My lord, now Roman 17 at page 18. Roman 17. It may be also mentioned that even the first 7 phases of counselings were conducted through a proper and transparent process with due notification and public counselling system, which was in the knowledge of all concerned stakeholders. There was no compromise with merit except those who had mismatch OMRs, and none of these so-called post-expiry candidates can be called to be tainted, nor were they featured in any of the lists submitted by CBI after a thorough investigation. Here, my lord, what is tainted, my lord? A process is said to be tainted if something is corrupt. My lord, if selection process is found to be illegal, the appointment made through that illegal process becomes corrupted. My lord, appointments given after expiry of panel is an illegal process which has been in paragraph 31 of the Supreme Court has declared, my lord. Now, any appointment through that illegal process, my lord, is a tainted process, and that is why, my lord, appointments are tainted, and that is why, my lord, the division bench in just Boishakhi Bhattacharya Supra, my lord, has stated that who are going to refund their salaries. It has been specifically stated in that, my lord, persons who have been appointed after expiry of the panel are the persons who are going to refund their salaries. And that portion, my lord, who are going to refund their salaries, the Supreme Court has tainted those persons, termed those persons as tainted, and has affirmed that portion, which I will place a little later on. My lord, thereafter, it's counseling for 11 and 12, my lord. Page number 19. Page number 19, my lord. The panel for classes 11-12 was published on 27th November 2017. However, the counseling process could not commence till the end of July 2018 due to substance of a stay order dated 11th November 2016, which was passed by this Honorable Court in Swanso. My lord, kindly your lordship remember, while in 9-10 an order was placed. It was talking, this paragraph talks about that order, my lord. Kindly mark the date. It is on oath, my lord. They have stated that it is in July, not before July. The counseling process was not started. Thereafter, my lord, next. It is stated that the second phase of counseling was subsequently held on 29th of August 2018. The third phase of counseling was delayed due to a major law and order issue. My lord, these are all common grounds that have been taken, although I will show from their affidavit the date of publication of the panel, and the counseling process for 9, 10, 11, 12 are quite different, and there was a substantial time gap, my lord, between those two counselings, but the point they have taken are all same, my lord. Thereafter, my lord, Roman 20 at page 20. It is stated that after the initial counseling, 3 teachers were recommended by the commission for appointment to the so-and-so high school, Uttar Pradesh, but on 20th September 2018, the students of the school started agitation against the appointment, and the protest against the appointment turned violent, resulting in the death of 2 persons. It is stated that on 22nd September 2018, the Commission submitted a report to the Honorable Minister in charge, Government of West Bengal, regarding the appointment. Then certain curative steps were taken to avoid such an unfortunate incident. This was an administrative issue that was also contributed to the delay from September 2018 to February 2019. My lord, Commission is an autonomous body, statutory body. They are, the 1997 Act has given them power to conduct a selection process, issue recommendation. My lord, they are under law, my lord, they are not bound to report to the Minister of Education that I have given a recommendation, appointment has given, students are agitating, so we are recalling back the appointment, so other counselings could not be done. My lord, this is unheard of. This shows the malice, my lord, the malafide of the commission in conducting the selection process, because all these counselings in between, after expiry, all these counseling has been made, my lord, just to accommodate those candidates who have Weimar mismatch or rank jumping, or, my lord, out of panel, those candidates, and, my lord, for other considerations. My lord, Roman 21. It is stated that 4th phase of counseling took place in September 2019. So, my lord, 3rd phase, 4th phase admitted after the date of publication of the panel, and the delay caused in it was partly administrative and partly due to the model code of conduct imposed in the light of 2019 parliamentary election. All at the same ground, my lord. The 5th and 6th phase counseling were held on 11th November 2019 and 19th November 2019. So, my lord, admittedly, these were all after expiry and the ground administrative inconvenience and, my lord, election. My lord, may I put this question to myself? My lord, commission was so, if the action of the commission was so bona fide, what stopped them from approaching the school education department or this honorable court? See, these are the problems, the panel may kindly be extended for the benefit of the students and teachers. They did not, my lord, because the rule did not permit them to do so. My lord, now your lordship has noted the date of publication of the panel and the 1st phase, 2nd phase council. Now, my lord, kindly come to their annexure, my lord, at R8 at page, my lord, 94 of their opposition.
Page
94.
94.
My lord, this is 11-12. This is the notification of the West Bengal School Service Commission for 11 and 12.
Yes.
My lord, kindly see date at serial number 9, date of publication of final panel. 27/11/2017. Now, my lord, from
This is in respect of classes 9 and 10.
11-12, my lord.
11, 12, where do I get it?
My
Is
lord,
it mentioned?
here, my lord, but it is not.
All right,
My
11.
lord, but where from it is getting, my lord? Kindly see, my lord, 2, serial number 2. From the total vacancies, it
All
can be
ascertained
ascertained that it is for 11-12. My lord, date of publication of panel, my lord, kindly note 27/11/2017. So, my lord, expiry is 27th November 2018. During this period, my lord, there was no model code of conduct, there was no parliamentary elections, nothing. All this happened after the expiry.
Yes.
Now, my lord, kindly see date of first counseling 16/7/2018 to 22nd July 2018. My lord, I say this is absolutely right, because your lordship now fall back to the date of counseling which the commission has stated in their opposition. My lord, that is at page or 11, 12, that is that page, my lord.
All right, there is no issue with the first phase and the second phase.
No, my lord. Why I am saying, they have stated, they have talked about an order that 25th July order, the order was, stay order was lifted on 25th of July 2018, that you can issue letter of recommendation. Only after that order, the counseling was started. That point was taken, my lord. Now, kindly see the date of first counseling, 16th to 22nd of July. Admittedly, on 25th July, the stay order was lifted, but what was the stay order? You will not issue any recommendation. There was no stay order on going through with the process of counseling. That is why, my lord, first and second phase counseling started even before that stay order was lifted, which is their contrary statement, which has been stated in their opposition, my lord. So, my lord, admittedly, they have started the counseling process before the stay order was lifted. That is why I wanted to.
All right.
And my lord, kindly see the second phase. Date of second counseling 29/8/2018. And kindly see date of third counseling 19/3/2019. My lord, what prevented them from the date of second phase of counseling to wait after so many months for the third phase? Because during this period, my lord, there was no model code of conduct, there was nothing. Well, the reason they took that there was agitation, there was law and order problem, and there are an Article 12 authority, there are state authorities. That means they are saying that the administrative machinery has failed, we cannot work. My lord, kindly see status of panel expired. Now, my lord, kindly come to page 95. This is for 910. My lord, your lordship will get that 910 from the total vacancy 12,905 at serial number 2.
Yes.
Now, my lord, serial number 9. Date of publication of final panel 12th of March 2018. Now, my lord, kindly see the time gap between the 910 publication of the panel and 1112 publication of the panel. One of the points, my lord, taken by the commission that there are several candidates of 910 and 1112 who are both listed in the same 910 as well as 11. Well, once 1112 panel was published first, so once a candidate's name is there in 1112, how could the commission say that he or she may also appear in the list of 910 when the list of 910 has not even seen the light of the day? So, my lord, the point taken that there was a stay in 1112, so we could not proceed with the 910 counseling is absolutely, my lord, false and misconstrued, my lord. It's a false statement to mislead this honorable court, my lord. Now, my lord, kindly see the date of first counseling 12/3/2018. Panel published on 12/3/2018. Date of first counseling 12/3/2018. Your lordship has got that?
Yes.
Now, my lord, one interesting thing I would like to show, my lord. Kindly come to page 9 of the opposition. 10 of the opposition. It's a purely false statement, my lord, which has been made on oath. Kindly see. Only on 6th September 2018, that is almost 6 months after the publication of the panel, the first counseling started. And my lord,
1 minute. Page 10, you say?
My lord, page 9.
Oh,
My lord, I am
page 9.
reading. The panel for 910 was published on 12th of March 2018, my lord. Now, kindly compare this with page 95, 12th March 2018. Now, my lord, the first phase of counseling could be started only on 6th September 2018. Kindly see the date. And now, my lord, page 95.
All right.
See, my lord, completely false statement. Even the second phase, all dates are wrong, my lord. Now, my lord, 5/2/2019. Kindly see, my lord, 12/3/2018, first phase of counseling. In 2018, no, my lord, model code of conduct, no stay order, nothing on counseling. After almost 1 year, this second phase of counseling started. Why, my lord? They are only saying law and order issue. My lord, I do not have to repeat myself, my lord. Now, my lord, kindly falls to serial number 21, status of panel. Expired on 18/12/2019. My lord, commission has no power to extend the panel, my lord, beyond 1 year. They are bound by the rules. Rules does not give them any power to do so. Thereafter it is for group C, group D, I am not. And my lord, it is these documents they have annexed as R8 in this opposition, my lord. Now, my lord, basically, the points which have been, firstly, it has been an admission on their part that after, for classes 9, 10 and 11, 12, both for classes 9, 10 and 11, 12, after second phase of counseling, all counselings were after the expiry. And the reasons they have stated, my lord, not a single reason is tenable. My lord, why? Model code of conduct not applicable. Law and order, it is not an administrative machinery failure. Then it has to be stated that it is a failure of administrative machinery. Second, commission, if commission is so bona fide in their action, they could have approached the school education department, because the rules have been framed by the school education department. They could have relaxed it, or they could have approached this honorable court to kindly extend the validity. We could not. These are the reasons they do not. And apart from all this, my lord, all these everything were argued and placed before the Honorable Supreme Court, and that is why in paragraph 31 it has been specifically stated that has tried to justify the extension of the validity of the panel. I will not repeat that, your lordship remembers. Now, my lord, kindly come to division bench judgment of Boishaki Bhattacharya, my lord, that thicker paragraph 363 ta bar korbo. My lord, Roman 4 I will place at page 272 of the judgment. My lord, Roman 4. Persons who had been appointed outside the panel after expiry of the panel, and also those who submitted blank membership but obtained appointments, must return all remunerations and benefit received by them to the state exchequer, along with interest calculated at 12%. My lord, the division bench was very conscious about this, and the division bench, there are 17 types of illegalities in paragraph 335. The division bench, my lord, could have said all those 17 illegalities who have got the benefit are entitled to refund their salary. But my lord, division bench was very conscious and only stated 3 categories of persons: outside panel, expiry of panel, and blank OMR. Not only, my lord, the OMR could have been OMR mismatch, but there are 2 categories of OMR mismatch, my lord. One who have got 10 given 53, another is submitted blank given 53. The division bench was categorical, only blank OMR after expiry and out of panel will refund their salary because they are found to be tainted. And how, my lord, this paragraph had been dealt with by the Honorable Supreme Court. My lord, paragraph 45, and this is at our writ petition, page 67.
3rd April's order? 3rd April's order?
Yes, 3rd April.
All right.
My lord, page 67 of my writ petition.
Paragraph 45.
45.
Yes.
The lordship has got that?
Yes.
My lord, I am reading. The last question relates to the relief and whether it requires any modification. We find no valid ground or reasons to interfere with the direction of the High Court that the service of tainted candidates were appointed must be terminated, and they should be required to refund any salaries or the payments received. Since their appointments were result of fraud, this amounts to cheating. Therefore, we see no justification to alter this direction. My lord, this relates to Roman 4 of paragraph 363. My lord, this says that those appointments were found to be fraud and tainted. We find no justification to interfere, and they should refund their salaries. So, my lord, in effect, 363 Roman 4 has been upheld by the Honorable Supreme Court, saying that after expiry of panel is a tainted candidate. And my lord, the Honorable Supreme Court in this way has in fact given a list who are the tainted candidates. Those are the tainted candidates who will refund their salary, and my lord, we will not be able to sit in the examinations and everything. So in a effect, my lord, Supreme Court has clarified, my lord, categorized who are the tainted candidates. Now, my lord, I have already placed the judgment of another division bench of our High Court in Sanjay Doli, presided over by Justice Soumen Sen, my lord. Where, my lord, in paragraph 32, my lord, your lordship remembers, that division bench has also categorically noted that after expiry of panel is a tainted candidate. My lord, I have given that judgment. এখানে দেখো বার করা আছে।
Is Sanjoy Doloi in the compilation? Not in
I
this
have given that.
All right. Where?
Better I've annexed that.
No,
আমি
I'll get jumbled. It's
No, no, I
from
have
your
given
brief.
that.
From you've handed over copy?
My lord, I have another copy, my lord.
Wait. Please wait. Yes, Sanjoy Doloi, 10th July is here.
My lord, paragraph 32. Paragraph 32 at page 23. Paragraph 363, Roman 4 has classified three categories of candidates who can be described as tainted candidates. Persons who have been tainted outside the panel, persons tainted after expiry of the panel, and persons who have submitted blank OMR sheets to obtain appointments. Now, my lord, what was this appeal for? My lord, this petitioner, my lord, filed a petition before the single bench saying that tainted candidates are being allowed to participate in the 2025 recruitment process. The single bench, my lord, declared that no tainted candidates would be allowed to participate. From this, my lord, interestingly, state and commission preferred an appeal saying that no, tainted candidates must be allowed to participate. My lord, now what is the direction? Your lordship has seen paragraph 32. Now, my lord, what is the direction? My lord, paragraph 33, my lord, kindly come to paragraph 33 once. It is really shocking and baffling that the appellants are supporting the tainted candidates. None of the three categories of the candidates mentioned in the orders of the Honorable Division Bench and the Honorable Supreme Court deserve any consideration. The argument that these candidates should have a level playing field on the basis of Article 16 of the Constitution of India is clearly not acceptable, as it would mitigate against the basic notion of justice and fairness. It cannot be the fundamental policy of the state to encourage fraudsters in public employment. They have no place in the system. If someone gets any job by way of cheating, then such appointment tantamounts to be a fraudulent and illegal, and he cannot be permitted to participate in the selection process initiated for filling up the vacancy which had resulted due to his unlawful and illegal action. The judgment of the division bench as well as the Honorable Supreme Court could show that the board has admitted the guilt and the entire selection process was set aside as it was vitiated by reason of fraud and collusion of tainted candidates with the members of the board and other agencies. My lord, kindly these observations, these were not challenged before the Supreme Court, my lord. Now, my lord, kindly come to paragraph page 28 at paragraph 40. The decision, my lord.
Yes.
In view thereof, we are not allowing any applications to be filled by the tainted candidates for the recruitment process initiated pursuant to the order of the Honorable Supreme Court. So, my lord, there is a specific order. Paragraph 40 has to be read with paragraph 32, my lord. It has to be read as a whole, not in isolation. Paragraph 40 is a result of paragraph 32, which says that these three categories of candidates will not be allowed to sit in this 2025 recruitment process. Even after this order, my lord, the commission has allowed every candidate to sit for the selection process. Now, my lord, a point has been taken. Now, as far as, before coming to that, as far as state's replies, opposition is concerned, I say, my lord, state is not a party, my lord, not a necessary party in this litigation, though they have been made parties and they have filed their opposition. Why? My lord, this relates to the conducting of the selection process based on the rules. This petition does not relate to interpretation of the rules or challenge to the rules. State has only framed the rules. It is the commission under the 1997 Act that has to abide by the rules and act in accordance with the rules. So whether the appointments were given after expiry, whether appointments were panel has been expired or not, well, these are the things to be answered by the commission, they being the recruiting authority. State is not the recruiting authority, my lord. So my lord, though the points grounds are absolutely same, my lord, I am not going to, I will rely whatever submission I made in in commission's opposition, my reply would be same. Only addition, my lord, state is not a necessary party here, because state has also in their opposition has said that all these are information derived from the records, not true to their knowledge. And what is not true to their knowledge, information derived from the records, that cannot, they not being a necessary party, not being the recruiting authority, they cannot say whether these candidates have been appointed after expiry or within the expiry. Now, my lord, a point has been taken. What is, the appointments may be illegal, but the appointments are not tainted. That, my lord, I have already shown from the Supreme Court judgment that these appointments have been termed as illegal as well as tainted. But for, if you're, my lord, only once, my lord, what is tainted? It is not. My lord, this is, kindly see, my lord, from Black's Law Dictionary. I will not place tainted. What is the meaning of tainted? Corrupt. Second. My lord, the second one. Kindly see the tainted, the second one. My lord, it tainted, any taint process which is tainted cannot stand alone unless and until that is illegal, one cannot be tainted, my lord. And my lord, the Honorable Supreme Court in paragraph 45 had categorically stated that persons who have been directed to refund their salaries are all tainted. And paragraph 363(4) says what the persons who are termed as tainted and who are going to refund their salaries. Now, my lord, only as far as the opposition of the private respondents, my lord, I say, my lord, though they have been added as respondents, my lord, I say they cannot have any say, because whether their appointments are they have been given appointment after expiry or not are to be answered by the commission. They are the candidates, they cannot say what caused delay and everything, my lord. It is the commission who is going to explain, my lord, whether their appointment is within expiry or after expiry. So, my lord, if their appointments are after expiry, they are absolutely bad in law and they are not permitted to, they cannot be permitted to sit for this instant recruitment process, my lord. And my lord, I am not giving any reply to the affidavits of the private respondents, and my whatever I have submitted in commission, my reply will be same. Another point, my lord, it has been stated that CBI has not said that these are tainted or not. My lord, it has not been placed. If it is so placed that CBI charge sheet does not say so, I will in reply I will say that CBI says that they have investigated after expiry. But my lord, the number of candidates may vary, because CBI has processed, my lord, on the basis of the expiry list, date of expiration which have been provided to them by the commission. Because my lord, CBI is not somebody to say when the panel has expired. The commission has given the date, suppose after 2 years, they will take that date as the after expiry date and they will proceed. Even taking that date, CBI has come to a conclusion that it has expired, appointments have been given after expiry. But be that as it may, but even if CBI has not filed any charge sheet, had not said anything after expiry, my lord, it cannot be said that because of that, expiry of panel or candidates who have been appointed after expiry cannot be said to be tainted or illegal, my lord. Because if the law is something, and if something is done contrary to that law, my lord, that is illegal. Now, my lord, only I would like to place two judgments of the Supreme Court in this regard. First is, my lord, 1996, 2 SSC, page 7. My lord, paragraph 6. 1996, 2 SSC 7. My lord, paragraph 6. My lord, may I read?
Yes.
From the aforementioned fact, it is clear that the selection committee had prepared the panel or list on 19/1/1991. The first batch of 98 appointments were made therefrom. The reservation rules were then modified. The second batch, as per the said modified rules, was sent later on 5/6/1991. But the panel was one prepared on 19/1/1991. Rules provide appointments and professional rules so and so. Every teacher will be appointed on probation for 2 years. The list of candidates prepared for direct appointment will be valid for 1 year from the date of approval of the project by the selection committee. It is also 1 year. The life or duration of the panel or list was therefore for 1 year of 1 year. It therefore expired on 18/1/1992 by force of the above quoted rule. The rules having been framed under Article 309 of the Constitution therefore had statutory force. Here, my lord, the 2016 rules have been framed in terms of the 1997 Act. Statutory force. The appellant state was therefore right in contending that continuance of the panel or list beyond 1 year would be a violation of the statutory rule and therefore illegal. Even the court could not stop it from lapsing it in exercise of judicial discretion unless its constitutional validity was. My lord, here the Supreme Court is saying even the court cannot extend the validity of the panel. Here, my lord, this is what I would like to present. Another judgment, my lord, 2010 টাকা। My lord, 2010 6 SCC 777. My lord, paragraph 22. Paragraph 22. My lord, there are several judgments. Only I am placing these judgments. So this is the, my lord, view which has been taken by the Supreme Court consistently, my lord. Paragraph 22, my lord. The tribunal, after recording the finding of fact that the life of select list had expired, held that as the selection could not be held in subsequent years, thus the candidates whose names appeared in the panel should be offered appointment by granting relaxation of the rules. Issuance of such a direction is not permissible in law, as no appointment can be made from the panel after expiry of the life of the select list. But I am not placing the other paragraphs. So, my lord, if I sum up my argument, my lord, it says, my lord, whatever may be the reason for not conducting counseling within the validity of the panel, any counseling conducted after the validity of the panel, my lord, is bad, and subsequent to that counseling, any recommendation appointments are also bad. This is my first. And there is no justification given by the commission which is sustainable that what prevented them from conducting the counseling. I have also shown from their opposition they have intentionally, my lord, tried to mislead this court by giving wrong dates to this honorable court, my lord, of the date of counseling. And my lord, what point they have taken that because of pendency of a matter, counseling could not be conducted is also a false statement, because their document shows that counseling has in fact was conducted. And my lord, and my lord, whatever has been argued here has been argued before the honorable Supreme Court, and after considering everything, the Supreme Court has declared this illegal. And as my lord, illegal and tainted, I have already submitted. Now, my lord, in paragraph, I must say this, my lord, in paragraph 31 of the Supreme Court judgment, there is one paragraph that in stray cases, High Court has given appointment. My lord, High Court cannot even give an appointment after expiry. But those appointments which have been given by the High Court, my lord, those persons are the victims of corruption, my lord. Those appointments, my lord, cannot be termed to be illegal and tainted because they were the victims of corruption. They approached the High Court. See, we have the victims. There are vacancies. Give us appointment. High Court erroneously, my lord, directed appointment, which the Supreme Court says even the High Court cannot. So, my lord, those appointments which are given by order of the High Court, that there are vacancies, you give appointment, those may not be termed as tainted and illegal. These are my submissions, my lord. with regard to expiry of panel. Another only one thing আমার reply টা দাও commissioner. Only one thing I would like to show, my lord. My reply to the commission. Reply to the commission is 13th of January.
Yes.
My lord, only page 8. My lord, why I am showing this? This is the notification for publication of the panel. This is for 11/12, my lord. Kindly mark the date. This is the publication. And my lord, next page 10 is for 9/10. Page 10 for 9/10. My lord, I say all these candidates who have been appointed for 19 and 11/12 after expiry of panel should be, my lord, Bird. They have already participated. They are in the select list in 11/12 and 9/10 verification not started. They are the candidates who should not be allowed to participate in terms of, my lord, 2 division bench judgment as well as of the Honorable Supreme Court and the 2016 rules. These are my submissions. And my lord, I adopt all these submissions, my lord, in respect of the oppositions which have been filed by the private respondent. Another submission was, since I have completed, my lord, your lordship may not be kind, allow, my lord, any further addition of party after 20, because I do not know what else they will declare.
All these have been placed in respect of Probir Midda.
Probir Midda.
All right.
Well, I have not completed.
This matter,
The
I
next-
appear for the respondent, that my application for additional party was allowed, and I have responded to his application, writ petition. Milord, he has chosen, Milord, not to respond to my affidavit for the simple reason, Milord, he has taken a consistent stand, Milord, saying that my appointment, Milord, that was granted, Milord, as a sequel to the order, Milord, passed by this honorable court should not be treated as tainted. Number one. Number two, Milord,
Were you appointed in that matter, Setabuddin?
Tamburi.
Setabuddin matter, which there is an order to appoint 102 candidates. Are you in that list?
No, no.
My lord, I tell you there are 2 persons. One is 102.
Huh.
Another order they have talked about, my lord, subsequently, not in 102, subsequently by another order, appointment was directed to
How many candidates?
1 candidate and 102 and 1.
And your
That
lordship
means
also.
103 candidates.
And my lord also kind enough, Milord, so far as my candidature is concerned, Milord. First, Milord, I got appointment, Milord, in an application for addition of party, Milord. His lordship Justice Gangopadhyay was kind enough to direct the commission, Milord, to grant recommendation, Milord. As a sequel thereto, Milord, I was appointed. Number one. Milord, an intra-court appeal was preferred by the commission. The division bench presided over by Justice Shane, Milord, affirmed the order passed by Justice Gangopadhyay, Milord, as his lordship then was, and the commission, Milord, did not prefer any appeal before the Honorable Supreme Court. So, Milord, that order binds. Milord, I have been working there. Now, Milord, the Honorable the Mr. Dashgupta, Milord, has said, Milord, the last occasion also, Milord, so far as I am concerned, Milord, this sole candidate, solitary instance, Milord, my appointment has not been questioned. If that is the submission, Milord, so whether, Milord, I am entitled or correct in saying, Milord, that by reason of such submission, since, Milord, he has just few minutes ago, Milord, he has also submitted, whether, Milord, my name can be expunged from the proceedings, since, Milord, the petitioner is not making any allegation, Milord, with regard to the mode of appointment.
But then it is you who filed application for addition of party.
Because,
The
Milord,
petitioner has not added you.
Milord,
The
no,
petitioner did
because,
not.
Milord, Milord, an impression was given to me, Milord, I was given to understand, Milord, the persons, Milord, were favored with the court's order, Milord, that is also a subject matter of a judicial scrutiny. So, Milord, my apprehension at that point of time, Milord, had it been a case, Milord,
What is the name of your client and the
Priyanka Shaw.
application number?
Milord, can 1 to? Can 1. And can 6, Milord, Mr. Ujjwal Rai, Milord, his application.
So it's similarly standing.
Can 1 and can 6?
Can 1 and
1 and
Animeshwar, 1 and 5?
5.
1 5.
1 and 5.
Can 1 and can 5? একটু দেখি না, please.
And in this
You
matter-
both these set of candidates were appointed pursuant to order passed by
By this
court.
honorable court, inter-court appeal preferred, Millard, the division bench affirmed the direction, and not only that, Millard, the commission did not prefer any appeal against this order. So, Millard, commission accepted the order. So, today, Millard, yes. So, today, Millard, there is no point in pursuing the litigation, Millard, against my client.
It is you who got yourself
No, I
included.
got myself, Millard, including because his submission was to the extent, Millard, that but I tell you, Lordship, on the first day, Millard, Mr. Dashgupta, Millard, has made it clear. Even then, Millard, since on that day, Millard, your Lordship said that, let me hear this.
Yes, let
Yes.
make up
So,
my
Millard-
mind until I get to know the facts of the case. I couldn't
Yes.
decide.
Now, Millard, your Lordship, in a different matter, writ petition filed by my client, directed the commission, Millard, in view of the other three orders, Millard, to consider my case. The commission has considered my case, Millard, so far as the experience marks is concerned.
That is different.
That is different. So today, Millard, no, আমি জজ সাহেবকে বলছি. So, Millard, if your Lordship records his submission, Millard, and Millard expunge my name so that I can be.
His recording will not do. Now he has placed his case. The case is here before the court. I have to hear all the parties and then take a call. Right? Only by relying on what he submits, it
No,
cannot be
Millard,
done.
permit me to file my, Millard, then Millard, let me submit to the next day, Millard, so that I can argue, Millard, if your Lordship wants to hear, Millard, I can deal with his submission. Since, Millard, his principal submission, Millard, is this, Millard, that he is not placing anything against me, Millard. So even then, Millard, in vacuum, Millard, I will try to, Millard, read for my Lord's kind consideration, Millard. The Millard, it is not a knee-jerk reaction, but still then, Millard, I need to, Millard, go through some.
Yes, please do.
Yes, Millard.
এটাতে কতগুলো পার্টি আছে?
No, let's-
Can 5?
Can 5
How
and
many applicants are there?
Can 5?
Quite a few.
Can 5?
Can five, but let us complete from our side, then we'll have the private respondents.
Our side means?
The two more matters are there. 91, 92.
Yes, I'll hear just now. This is in connection with Probir Midda. That is the reason.
11 director.
31 applicants,
Yes, ma'am.
all appointed.
I just take your Lordship, and may I just see this name, the first name of the applicant?
First name is Saddam Hussein,
Yes, that one.
a very famous name.
Millard, may I take my Lord's kind leave? I'm leaving you.
Yes,
Uh,
all of them have been engaged by the order of this honorable court.
by orders of court.